Thank you, Mr Speaker. I'm pleased to note that the Honourable Chris Finlayson is Minister in the House now, or is a Minister in the House. His colleague, the Honourable Dr Nick Smith, was in the chair for most of the night on this bill and unfortunately didn't address the issues that we raised that still remain outstanding as to what is going to be the effect of the Trans-Pacific Partnership negotiations on the length of the period of copyright and whether the Section 92 or Clause 92 provisions in this bill are going to be reopened. Because according to the Herald on the 31st of March, from the content of leaked proposals by the United States government in the Trans-Pacific Partnership negotiations, these things are on the table, and the United States wants to lengthen the period of copyright so as to benefit their monopoly holders of those copyrights, and also to reopen the issue as to what responsibility internet providers should have in respect of breaches of copyright that are carried out through the services that they provide. Mr Chairman, the policy issues and the Labour Party position on this bill has been well outlined by Claire Curran, and I'm not going to go into that again, but I do want to just place on record that I think it's unsatisfactory that the Minister in the chair, despite the fact that this issue has been the subject of prominent publicity, wasn't able to give us any assurance that they weren't going to bend on these issues. Now, I believe in copyright, but I don't believe in open-ended copyright periods. I don't believe in unrestrained monopoly rights in any area. You know, if you develop something that's patented, which has actually got novelty and a lot of other steps that have to be proven before you get in a patent, your patent doesn't last for 50 years beyond the term of the life of the person that made the invention. It doesn't last that long. A patent right is a lot shorter in term of years than we already have for copyright, which currently goes for 50 years beyond the life of the creator. And the United States want to extend that to 70. Now, the theory that lies behind copyright is not advanced by extending the copyright period. The theory that lies behind copyright is that there has to be some fair reward available to the person that creates creative content or is suitable for copyright and designs and things, and that is important to allow that through copyright. Otherwise, we won't get people being able to afford to actually produce the content that makes us richer as a society. And I don't just mean richer in a money sense, I mean culturally richer because we have the result of creative endeavour. So that's the theory behind it. If you don't have some rights to copyright, and until copyright was invented, and it was actually a common law invention originally in the United Kingdom, until then people could write a book, and then next day someone could rip it off. So they could produce the book that someone else might have laboured 10 years to produce. The person who spent the 10 years could be left penniless, and the person that ripped it off and then printed it could make a fortune. And that was wrong, apart from anything else. It would have, if that had persisted, you wouldn't get many people writing books, and we'd all be the poorer for it. So that's essentially why we have copyright. But you don't actually have to have copyright for the life of the author plus 50 years after their death in order to encourage people to write books. It's already gone a lot further than that if you think about it. In practice, people don't write a book because someone's going to get a royalty potentially 50 years after they've died. That's not real. And the fact that the Americans want to extend that to 70 years after the death of the person that writes, it's just patently about money. It's not about creativity. It's actually about extending the monopoly rights that the copyright holder has. And it just doesn't... They are a monopoly. A copyright is a monopoly. Did I hear you say they're not a monopoly? That's completely wrong. That's what you get if you've got copyright. You've got the right to control who copies it. You're the only person that has the right to legally copy it. You have monopoly rights. It's a personal property right. It's a monopoly personal property right. It's an intangible right, as one member... what's that? Yeah, no. What, did he agree, what? That the term should not be expended beyond 50 years? No, well, look, no one's disagreeing that it's a property right. No one's disagreeing that it's a property right. We're just saying that there should be limits to that copyright. there should be limits, and the Minister would not go on record and say that it ought not to be extended beyond the existing term of 50 years after the death of the person that created the material that is the subject to copyright. And this is just so typical of this government that really rules for the big end of town, because the big end of town are the ones that benefit from extended use of those monopoly rights. Beg your pardon? Employees of those corporations. Oh, I see. So there's going to be some trickle-down theory. Look, you know, look, I've got no problem with people making money. I actually like businesses to succeed and make money. I actually like making money myself. It's nothing to be ashamed of. But we ought not to be conferring monopoly rights that give people a privileged right to extract a monopoly rent for an unfairly long term. And that's why I made reference at the start of this to the theory that lies behind copyright, because we should have recourse to that underlying theory, which is to encourage creativity and creative content to be formed for the benefit of society. And when you have lengths of copyright that are longer than are necessary to achieve that, don't kid yourself that you're doing it in pursuit of the theory that lies behind copyright. You're not. You're actually agreeing to longer terms because it's in the monopolistic interests of those people that have got that preeminent position as a consequence of monopoly, as a consequence of their copyright, and they want it to go on longer. That's all that's happening. So the government ought to be clear and said, we're not going to agree to that with socialised career. Oh no, look, you just don't get it, Mr. Tremaine. You just don't get it. Just like Dr. Nick Smith didn't get it, but actually I do trust that Chris Finlayson will get it, and that's why I'm raising the issue, because I hope he keeps an eye on this in the negotiations in the Trans-Pacific Partnership, because otherwise we will make New Zealand poorer as a country overall, not richer. We will get poorer as a country overall, not richer, by agreeing to those sorts of unwise terms. Look, we don't agree to ridiculously long lengths of patents. Why should we have overly long length of period of copyright protection? That's all I'm saying, and we still haven't had an answer from the government on that. The other issue, it would be a nonsense to go through all of this and then reopen it again, the Section 92 debate. Now, I'm actually not one who says that internet providers ought to be free of all responsibility in respect of protecting other people's property rights. That's a cop-out. Having said that, there are technological difficulties that can't be ignored. It's no use having laws that are patently unenforceable, and that was one of the problems of the underlying law before its reform. And I don't approve of laws that sit there theoretically on the statute book but can't in practice be enforced, because that actually brings the law into disrepute too. So, Mr. Speaker, I support the Copyright Infringing File Sharing Amendment Bill, but I am concerned that this government is too permissive of monopoly excess. Monopolies, we hear people sort of claim this is private enterprise. You know, monopolies aren't an example of free enterprise. Free enterprise relies upon, in its proper form in my view, relies upon competitive markets. These are exceptions to competitive markets. The government's too ready to agree to uncompetitive markets in New Zealand. The National Party's done it before in respect of lines companies. We still have it in respect of power companies, where we've got proven monopoly excess, gouging of consumers through excessive monopoly-based power being used to excessively price electricity in New Zealand. We've seen it before in New Zealand in respect of telecommunications. We've got a current piece of legislation going through this House which is going to create monopoly rights in respect of some incumbents in the broadband arena, widely opposed by most broadband market participants as being anti-competitive, and yet still being pursued by this government. So in New Zealand, people are right to be suspicious of this government when it comes to their control of monopoly excess, and I certainly am. Thank you, Mr. Speaker.